In an op-ed for Washington Post, President Biden called to reform the Supreme Court, including proposing a constitutional amendment to remove presidential immunity, term limits for the Supreme Court justices themselves, and a binding code of ethics over the Supreme Court. So why the hell is this happening? Stick with me and we'll discuss. Hello, all you beautiful people. World's Okayest lawyer here, kind of giggling about how bad of a job the left or the Democratic Party is doing right now. And that goes all the way back to parading President Biden out there as the most lucid president in the history of all presidents ever. Well, we discovered that was a lie. So the Supreme Court ruled that a president cannot be prosecuted for official acts in Trump versus United States back in July. And ever since then, the left has been real pissed, which makes zero sense to me. Why? Because even though it benefited President or former President Trump, it would benefit them too whenever they get a president in. I mean, wow. So President Biden claims that what we were seeing is unprecedented, and he could not be more wrong about that. During Franklin Delano Roosevelt's presidency, or FDR if you will, he was struggling to get his New Deal agenda through the Supreme Court. And if you don't know what the New Deal is, an easy thing that affects our lives today in the United States is Social Security. That was part of the New Deal. What is now Medicare, Medicaid, that was part of the New Deal. Having to pay income taxes, that is part of the New Deal. So you can thank FDR every April 15th when you have to file your taxes. Yes, indeed, it's when the IRS knows exactly how much you owe, but you who do not know what their secret number is have to guess. So thank FDR for that. But I digress. So what the hell is exactly the problem? Well, right now the conservatives have a 5.5 to 3.5 majority. Why do I say 5.5 to 3.5 instead of a 6-3 majority like legitimately everywhere else? Well, that is because Chief Justice Roberts has a tendency of bouncing back and forth between the conservative branch of the Supreme Court and the liberal branch of the Supreme Court. So sometimes he is the fourth decision for the liberal side, and sometimes he is the sixth decision for the conservative side. But regardless, whenever he's doing that, as long as a conservative justice doesn't jump over, the conservatives right now would still have a 5-4 majority. So that is why they are kind of pissed right now. So what President Biden has kind of thrown out there is a bill called No One is Above the Law Amendment. And it's also being pushed by Harris right now as well. And it has about a 0% chance of ever passing in the current setup of the Congress of the United States. But are they even going the right damn path? Absolutely not. They could call for a constitutional convention, which really hasn't happened since 1787, but they could still do it. And that's when the states essentially are the ones that call for a constitutional amendment. What they're doing right now, and the reason why I say that it's wrong, is because they waited until President Biden had the least amount of strength or power, if you will, within his presidency, when he should have done it there at the very beginning, because they really have honestly been bitching about the Supreme Court justices and the fact that there's no term limits going all the way back to day one, going all the way back to whenever he was running. How about that? And yet they waited until he is actually called or announced that he is actually not going to be pursuing the 2024 election for his second term for presidency. But how would this actually work? So based off of what they're doing right now, this is technically a right path where Congress is the one that passes a bill from both a 2/3 of the House of Representatives and 2/3 of Senate, and if they can get that done, then it will then go to the states. So right now, in order to get the states, they would have to have 38 states, or 3/4 of all of the states, to ratify this amendment should it hypothetically pass, which it won't. And according to ballotpedia.org, Republicans actually control 55% of the state legislation seats nationwide, or 28 of the 50 states, leaving only 22 that would buy into the amendment. So, and that's hypothetically buy into it. That's 22 states. They need 38. They ain't getting it. So what starts making everything sideways is when folks like AOC put in articles of impeachment against Clarence Thomas and Samuel Alito, neither of which should go anywhere either, because disagreeing with someone is not enough to impeach. Impeachment requires legitimate, illegal, or unethical acts, which neither has really occurred. I'm sorry, as much as you may be pissed that Clarence Thomas's wife has done stuff, whether Samuel Alito's wife has done stuff, that's not them. So if their wife goes and robs a liquor store, Clarence Thomas and Samuel Alito are not getting arrested unless they're driving the giveaway car, because then at that point they've done an illegal act. They've really not done anything unethical either, which I'm going to explain why. So I know, you're going to say something about recusal, right? That is the unethical aspect. But the lack of recusal goes all the way back to when Chief Justice John Marshall failed to recuse himself in Marbury versus Madison, when he was actually the reason the damn case was there to begin with. Don't believe me? Well, here's the story. No shit, there he was. John Marshall is Secretary of State under under John Adams. So under John Adams, he is Secretary of State. Part of his duties as Secretary of State at that time was to go ahead and sign off of nomination for federal judges. There was this one judge by the name of, you'll never guess it, but it was Marbury. And he did not get his judgeship that he was promised by John Marshall himself that he would actually get. So John, and all of his, hey, I'm trying to get out of here so the next administration can take over, pop smoke. The new administration comes in, looks right down at the desk. They see the nomination for Marbury. Madison grabs that, wads it up into a ball, shoots it, sinks it for a 3 from way downtown, and then the lawsuit starts. Gets all the way to the Supreme Court, and at least Marbury was smart. Marshall was smart. He did not grant Marbury his slot, but what they did is, in this unethical situation, they did a power grab to where they created more power for the Supreme Court that they held, and they still kind of hold, but not to the extent, because Roger Taney kind of messed that all up back during Abraham Lincoln's time. So, if this is going to fail, what could the left do? Well, they could honestly get rid of every court except the Supreme Court unilaterally, because the Supreme Court of the United States is the only court guaranteed by the Constitution of the United States. And Congress is the one that determines whether or not the lower federal courts, and that includes, I'm talking lower than the Supreme Court, so I'm not talking about just district courts, I'm talking about the appellate courts as well. They're the ones that determine whether or not those candidates for those judicial seats actually get them. Don't believe me? Check out Article 3, Section 1 of the Constitution, where the power vests in a Supreme Court. Literally written right there in black and white. Like what I had to say, please sure to follow, like, review, and subscribe to me. I can't believe that you're willing to listen to what my world's okayest opinions are. Lastly, it costs $0 to be kind. It's the best money that you'll ever spend. Until next time, beautiful people, peace.